Today our series is about the ins and outs of estate planning. We're going to talk about estate planning techniques, benefits of charitable giving, tools of charitable giving, and powers of attorney. And we reached out, but we didn't have to reach far. We got two prominent Hillsboro attorneys here with us today. Jack Stewart and Bianca Eden of the Wegmann Law firm are here to talk to us about charitable giving and also how we can do some estate planning. And like I say, I hope answer any questions you might have along the way. So if you will help me welcome Jack Stewart and Bianca Eden.
I'm Jack, if you hadn't guessed. I wanted to go first because Bianca's better looking than I am, and so if she went first, she probably wouldn't listen to me. I'm a graduate of the University of Missouri. I had a bachelor's degree in agricultural economics. I came off the farm in North Missouri. I then went to law school, and then I practiced law with the JAG Corps for 5 years. Spent 3 of that in Germany. I've been with what is now known as the Wegmann Law firm since 1970. In fact, they honored me for having completed 40 years last November. I do work in wills, powers of attorney, trusts, estate planning, real estate. I used to do a lot of dissolution of marriage. I represent political subdivisions, 4 schools, 4 cities that the firm does, the health center, the library district, a number of water and sewer districts, and then we do probate estates and administrations of trusts. So we do a lot of different things. So we bring to our clients not only the wills, the trusts, powers of attorney, but also the legal experience in all of these other areas that often affect your estate planning. My partner, Bianca Eden, of course, we are 2 of the 8 lawyers in our firm. We all work together for the good of our clients. Bianca has been practicing with us for about 11 years and specializes in trusts, wills, probate, land transaction. She's the prosecutor at the municipal court in Hillsboro, and she does taxes. Bianca came from a family where there are 4 girls. She and her husband have a daughter 3 and a son that's 7 months. She's also a graduate of the University of Missouri Law School, and her work included work in estate planning and tax specialization courses. So that's who we are. We practice in Jefferson County and other areas. We know the judges and we know the clerks, so hopefully we can get around here pretty well. The question I thought I might pose to you is the question of what is estate planning? We hear it on the radio all the time, and actually what it is, it's about getting an expert help in planning what will happen to you, your spouse, your kids, and the assets you have worked so long to enjoy and preserve for yourself, your spouse and your kids. When, not if, you become disabled or pass on. I like to say, not in a joyful way, but we're not going to get out of this alive. And since that's true, it's really smart to start thinking while we have our wits about us that what we want to do to preserve our assets for our own use and to get as many of them when we're gone over to our family. And of course, I don't want to sound morbid, but if we don't review our assets and next of kin with a view towards having the most assets for us and our next of kins, then unfavorable things can happen, which can be avoided. Right now is an interesting time to be talking about estate planning because taxes, of course, have been being reduced over a long period of time. Death taxes, somewhat income taxes have been reduced. And now we've gotten to the point where last year, in 2010, there was absolutely no death tax in Missouri. The state has done away with their inheritance tax many years ago, and the IRS did away with the federal estate tax in 2010. But of course, Congress had a law that they agreed that they weren't going to increase the deficit beyond certain limits. And so by the end of 2010, they needed to put something in place, and so they did. They brought the estate tax back on January 1st, 2011, but it is brought back in a very modified way, and it's much more taxpayer friendly, because instead of talking about $30,000 of exemption, which was the law when I started here in 1970, now you talk about a $5 million exemption from death taxes. So that's a big change. Now let's dispel a few myths. One myth is if you die without a will, the state takes all of your assets. That's absolutely not true. If you died without a will, then of course your estate would be administered without a will. A personal representative would be appointed. The probate court costs wouldn't cost more than $150 to $700 depending on the size of your estate. And the lawyer who represents the personal representative, there are minimum fees that the statutes provide. They start out at 5%, but that's only for the first $5,000. Then they go on a limited scale until it gets down to 2%. On the average, lawyers' fees are less than realtors' fees for selling a piece of real estate. And they have at least an 8-month administration. Next thing is, if you have a will, you avoid probate. Well, that's not true either. Wills have to be administered by the probate court. They have to be accepted as your will, and then there has to be an administration. But if you have a will, it is easier to make it through the administration, and you get to select the personal representative. There's a very good reason why younger people should have wills, and that is, a will is the way for you to name the guardian and conservator of your children if something happens to you and the other parent. And that's critical, that you get to select who's going to raise your kids and handle their finances. And of course, I've touched on it a little bit already, but a lot of people, when they come in, they say, well, they don't say it to me, but they say it on the street to each other, that the lawyers in the probate court take all your money. And that is absolutely not true. In Jefferson County particularly, we have a very good system of probate. It is run efficiently. Pressure is put on the personal representative and the lawyer to keep things moving, and the judges do make correct decisions. So now let's move on to talk about what I'm supposed to review with you, and that is the benefits of a trust or a will. Now, the will takes care of what is in your own name at the time of your death, which does not become owned by someone else upon your death by reason of the way it is titled. Now, if you have joint tenancy or tenancy by the entirety of your real estate or whatever with your spouse or with your relatives or your kids, then joint tenancy means it belongs to the survivor. So it does not pass under your will. Tenancy by the entirety, by the way, is a joint tenancy for husbands and wives. It's only for husbands and wives. If you're not married, you can't have a tenancy by entirety ownership, but it's the same as joint property, joint tenancy. One big difference is if you have things in both names of husband and wife, then creditors usually cannot collect. If they have a judgment against one of you, they can't collect it out of the tenancy by entirety property. Now, at some point, that may go away. There was some talk 10, 12 years ago that it was under attack, but we have no cases in Missouri where it is not honored. A beneficiary deed, of course, transfers real estate automatically by reason of your death to your beneficiary. And so does a transfer on death ownership, so does pay on death. Life insurance, we all know, is payable to a beneficiary. Trust property does not pass through probate. It belongs to the successor trustee who is required to administer the assets in accordance with the trust. And of course, the probate court can administer a trust or control a trust if the beneficiaries believe that the trustee, the successor trustee, is not properly handling things and following the law. Now, if you have a trust, you probably still want to have what's called a pour-over will, which means if you don't get everything in your trust, and you know, to be in your trust, you have to title it that way. So if you go to the boat and win a lottery and then pass on the next day, it's not going to be in your trust. Now, that's not likely to happen, of course, but you can take some things like dividends from an old electric co-op. They're all over the state. Those things lay there and they're assets and nobody thinks about them. And then about 8 months or 2 years after somebody dies, they'll send you a letter or a check on all the accumulated dividends. So a pour-over will is a way to take all those assets that didn't get into the trust and put them into the trust after you're gone. Now, wills that are administered in probate or in probate are public, along with all estate assets and procedures. A lot of people don't like the idea of that. They want privacy with respect to what their assets are and who their beneficiaries are and who gets what. Trusts, on the other hand, are private. They're subject to an annual accounting to the beneficiaries once the trustee who created the revocable trust, for example, is gone. And so they do have to account, and they're subject to court review, as I mentioned, but only if somebody is willing to bring litigation. Wills are cheaper to have prepared and executed. And of course, you don't have to transfer assets anywhere, because the assets are in your own name or in the name of you and your wife and you're both gone, for example. They're automatically administered under your will. You don't have to transfer them into anything. Trusts, however, you have to put your assets into trust. And a lot of people go to seminars put on by a trade group or whatever, and they get the idea that trusts are wonderful, and they are. Unfortunately, sometimes the people who are selling them don't talk about the fact that they have to be administered and they have to be funded. If they're not funded, they're worthless. And so that's one of the advantages of having your work done by somebody local who stands behind their work after they've done the job. Now, trusts are usually more expensive to prepare and fund, but less expensive to administer. Uh, Excuse me, once the death occurs. Both the trust and the will can be amended, and the cost of amending them is about the same. An amendment of a trust can happen as long as it's revocable, which most estate planning trusts are until the creator of them dies. So they continue to be, can be amended, they can be done away with. People can get their property back in their own name if they want to. However, in order to make an amendment to your will or your trust, you have to have capacity, which means you have to be able to know most of what your estate is, and you have to know the natural objects of your bounty. In other words, you have to know who would ordinarily be your beneficiaries. Now, we've talked a little bit about non-probate instruments. We talked about life insurance that's been around forever. With life insurance, the policy has an insured, which is the person who the company pays when somebody dies. It has a beneficiary, and we all know about that because you leave it to your wife or your kids, whoever. But a lot of people don't think about the fact that it has an owner. And the owner of a life insurance policy is the person who applied for it. Might be the insured, might not be. Might be a beneficiary, might not be. The owner has the right to make changes in the beneficiary. And for estate planning purposes, that's important because it's important for death tax purposes. Now, the concept of beneficiaries goes back a long ways. The Italians had a very old non-probate transfer deal. It was called the tontine. And the tontine was where a group, and I'm sure they were men at the time, would get together and put assets under the control of one of them or a survivor or some other institution, and that money would stay there until all of them were gone. And then it would be paid to the survivor. And so it was kind of like a lottery. That principle goes back to the year 700, so that's how old it is. Now, of course, we have annuities, we have beneficiary deeds. When you do a beneficiary deed, it's not always easy to make it turn out all right as to who gets it, because sometimes the beneficiary dies before the creator dies, and that means it has to be payable to the lineal descendants of that person by the beneficiary deed, or it has to say that it does not belong to the descendants of the beneficiary. And if there's no beneficiary at all, then it goes into the estate and it's going to be administered under your will, or it could pour over, of course, into a trust. Then, of course, we have transfer on death ownership, and that has become very popular. In fact, a lot of banks, banks really don't like you to have your own name on an account. They want to have somebody to deal with if something happens to you. And there's some advantages to the bank's position. But in estate planning, that isn't necessarily what's good for you. So you'll need to think about that and have a bank that follows your wishes. One of the problems with transfer on death and pay on death ownership is some other states may not recognize them because we are still, 50 independent states. We're like 50 independent nations, and everybody can have their own rules as to what happens. Transfer on death ownerships and pay on death ownerships tend to be inflexible, and you have to watch them because if the wrong things happen, then you need to make changes. And of course, the owner of the assets can change the beneficiary deed or the transfer on death ownership anytime they want to, as long as they're still alive and as long as they have capacity, or they have a durable power of attorney, which appoints an agent to serve even if they are disabled. Joint tenants with right of survivorship is of course, a way to avoid probate, as well as tenancy by entireties and trust, as I mentioned. Now, if we talk about outright bequests, this is a bequest under the will that is simply a gift of personal property through a will. It doesn't happen, and your will does not become effective until your death. An absolute, an outright bequest means, of course, that the person who's receiving it doesn't have to invest it well or properly. They can surrender it if it's a valuable asset. They can put it in joint names with their spouse, and it becomes marital property. It can become marital property, and can go away with a divorce. It doesn't mean that the heir has to save anything for a rainy day. It's an absolute bequest. It cannot be used to reduce death taxes, like life tenancies and other kinds of ownership can. Now, the last thing I'm going to talk about is powers of attorney, and the Nancy Crusan case in Florida nationwide brought about durable powers of attorney in almost every state. Nancy Crusan, of course, was comatose, and I don't remember how many years it was, but it was many years. And some of her family wanted the plug pulled. Others of her family didn't, and so she laid there. And it caused a lot of us to think that maybe there is a time when it's just time to go on. And so the law in Missouri now is, if you want someone to have the authority to pull the plug when you're incapacitated, then it needs to be in your power of attorney. Now, durable powers, there are two kinds of powers of attorney. There's the regular power of attorney, which is revoked if you become incapacitated. The durable power of attorney continues in effect even if you are incapacitated. When do you need one? In my opinion, everybody should have one, so long as they have an agent that they can name as their agent who is responsible and who is not going to do things for their own best interest instead of your best interest. Now, you can sign one anytime you have capacity, and then the question is, who do you make the agent? And of course, if a person has 6 or 8 kids, they sometimes have a tendency to want to name 6 or 8 co-agents, and that's pretty unworkable. It doesn't work too bad with 2 or 3 if they all get along. But you can also name agents and then have alternates if that agent can't serve for any reason. And you can even make it so that the alternate serves even if the primary is out of pocket for the time being, and it's necessary to have someone. You can have more than one, as I said. The question is, who should you select? And that is a critical problem, because often families, even though they like to think that they're close together and fair with each other, if you have part of the children who are around mom and dad and look after mom and dad and do all sorts of things for the parents, then they begin to think that they didn't get to go out and make their fortune. And so those kids who went to California, have it easy. And the person who stayed at home has it rough, and so they began to feel sorry for themselves. While the kids in California, they're thinking, well, gosh, my brother or sister in Missouri got to be with mom and dad and get the benefit of all these years, so I should be favored now. So there's all sorts of things that can cause resentment among the kids. And so it's very important to make your selections and to pick good, solid representatives as agents and as personal representatives. Well, I'm going to turn it over now to Bianca and let her talk about the other subjects.
Two of the subjects that I'm going to talk about that I've kind of combined into what I call annual exclusion gifting is the ways to reduce your estate and reduce your income, and some of the ways that you can do that. So let me see if I can now operate this so that I show that I can do technology. Anyway, what constitutes a gift? A gift is any transaction whereby property or property rights are gratuitously given to another. So you're not receiving anything, and the love and affection that you receive from your children is still considered gratuitous. There's not any real monetary value placed to that. A gift is not complete until the donor, being the person who gives the gift, parts with control. And the IRS sets the maximum, the unified credit. It used to be $1 million. They've moved that to $5 million. And what that means is that over your lifetime, you can gift $5 million to an individual without incurring, to however many individuals you want to give, without incurring any gift tax. Now, there are some caveats to that, and what people don't understand is if you go out tomorrow, say you strike it big on Powerball and you're going to give your kids, you're going to split that with your kids. If you take control of that money and then you give certain portions to the children, those gifts, and those gifts total more than $5 million, you give it out, but upon your death, that $5 million that you gave away is still going to come back in. People don't understand that portion of it. Now, if you want to get rid of funds and make sure that they stay out of your estate, if you're lucky enough to have the estate tax problem, then the way to do that is to give to charities. Because when you give to a charity, it never comes back into your estate. And there is no limit as to those giftings. And I'll talk a little bit more about charitable giving as we go on. I'm half Italian and I tend to talk with my hands a lot, so that's why I've kind of set down the clicker. Anyway, who are your normal gift recipients? Most people want to give to family. If they don't have a close family, they might want to give to friends. There are foundations, churches, charities, and government. Now, for the purposes of the gift tax and what will count against your unified credit, it's only the gifts to family and friends that will count against your unified credit. Like I said, anything you give to foundations, charities, government, schools, libraries, that all comes out of your estate and never comes back in. Now, when you're gifting to family, there are still considerations to consider. If you have a spouse who's not a U.S. citizen, if you have children, grandchildren who are minors, or children or grandchildren who have special needs. These are all things that you need to consider because a part of estate planning is not only planning for death, but it's also planning for what you want to do with your funds during life. Normally, a married couple who reach that bracket of where you have a large enough estate that estate tax will be an issue for you. If normally you're never going to have a tax paid until the death of the second, because of the surviving spouse, because there is what's called the marital deduction. So if you have an estate, say your estate's 5,500,000, and the estate tax exemption is 5 million. On the first spouse to die, if you're both U.S. citizens, you still would not pay tax on that $500,000 in excess of 5 million because of the marital deduction. You can shift everything over to the surviving spouse. That does not occur if you have a non-citizen spouse. In the event of a non-citizen spouse, this is an exception to the marital deduction, you have limited gifting ability. You can only gift in 2011 $139,000 to that surviving spouse who's a non-citizen and have that be, that's the top that the marital deduction can be. And the IRS looks at the status of the spouse at the time of the gift. So I have my example that Paul, a U.S. citizen, gifts to his wife Greta, a German citizen, stock with a value of $200,000 in 2011. If Greta then the next year decides, I don't really care about being a German citizen anymore, the good old US of A is where I want to be and where I want to have my allegiance, then there's still going to be $61,000 deducted from his $5 million unified credit because he only could gift to her $139,000 without it counting against the credit. So there is some planning that you have to do in regards to spouses when they're a non-U.S. citizen. You have to do some extra planning in regards to that. What about minor children and grandchildren? A lot of people, you don't want to necessarily set up, you want to provide for your children or grandchildren. But say you don't like the idea of them obtaining control of a large sum of money at the age of 18. I was pretty mature at 18, and I don't think I would have done very well with a good sum of money. So it's probably never that good of an idea to give a lot of control to kids if possible at that early age. And what the Missouri Transfers to Minor Act allows for you to do is you can set aside funds for a child or grandchild and put the limitation that they're not to receive it until the age of 21. And it's a way to avoid setting up a trust, because say you're wanting to give, like say it's $50,000 or something along those lines. That's not necessarily an amount that you would want to have under a trustee's control. But the gift can go into this account, and you can put that provision that they don't receive it until 21. There's a custodian over the account that then can make, if you say you want to pay for education and things like that, they can still do the educational payments. Now, the one thing I didn't mention about gifting is for parents, if you're gifting to family or friends, there is an exclusion amount, which is different than the exemption amount. The exclusion amount, which is currently $13,000 per person. So you can go out and give $13,000 a piece to, say you have 6 grandchildren. You can give up to $13,000 a piece to them. That comes out of your estate, doesn't require the filing of a gift tax return, and that doesn't come back into your estate. That's the exclusion amount, as opposed to the exemption amount, which comes back into your estate. And another thing with minors and grandchildren, educational gifts. A lot of grandparents or parents, they want to pay for the education of their children. You can make payments directly to the educational institution. And this is more for grandparents. If you want to make payments directly to the educational institution, those payments are not subject to the exclusion amount, nor are they subject to the generation skipping tax. So you can make these payments without worrying about filing a 709, which is the gift tax return, or with worrying about it going against your unified credit. And also, you're not trusting that if you give the check to the grandchild that they're going to then pay for their educational bill instead of something else. So here, this was just my example, is that when you're in law school, they use a lot of G's and different things as instead of giving names to people. So that I've tended to stick to that whenever I do presentations. Say G's grandson attends private school, and G wants to pay that yearly tuition of $25,000. If he pays his son directly for the tuition, and then the son pays the school, he's got to file a Form 709 because he's exceeded the $13,000 exclusion amount by $12,000. So that $12,000 would then come off of his $5 million lifetime exemption. Whereas if he pays it directly to the school, he's not limited to that annual exclusion, and no part is claimed on a Form 709. The other thing is a trust. If you want to set up a trust for a grandchild, that trust the transfer of the trust is not considered a gift unless the trust is wholly, how did I put that? Sorry. It's always good when I confuse myself. In a trust, in order for that gift to be considered complete, whereby you've then gotten the money out of your estate, you cannot have that trust be owned by you. You can't be the grantor of it or have the ability to terminate it, because until you give up control of the money, it is still considered part of your estate. Another issue which you might run into is you have special needs children. Whereas you have a child who qualifies for certain governmental programs that are income-based. So if you want to set up a trust whereby it provides for the needs of those children, then what you have to do is you have to make sure that the trustee has discretion as to whether to pay or not to pay. If it's required that the funds go to the individual who's the beneficiary of the trust, that money is then counted as income for that individual. It also, if you're making a gift to a special needs trust, in order for it would need to be an irrevocable trust in order for it to qualify as a gift. And the most important part is the ultimate beneficiary of the trust cannot be the special needs child, because if it is the special needs child, then it's considered to be part of that child's estate and an asset that is counted against that child. And what people normally do is you have them be the income beneficiary of it, with the trustee having the ability to invade the principal if necessary to provide for these extras. But when I say ultimate beneficiary, the ultimate beneficiary is who would receive it when the trust terminates. And so if you have provisions where, and the trust is usually not going to terminate until the death of the special needs child, but that ultimate beneficiary needs to be someone other than the special needs child or the special needs child's estate. And like I said, it's the income and principal is used to supplement the income and programs that are provided through the child. Because a lot of times in some of these special needs cases, you could have a trust and you're thinking you're doing a good thing by giving all of this money to an individual, but say they have medical needs that are just astronomical. The trust may not cover that and will only disqualify them for a period of time from services that they're used to having. Then we have charitable giving. Charitable giving, there's a section of the IRS code which defines what charitable giving is, and for it to be a charitable gifting, it needs to either be a governmental entity, a 501c3 organization. We have fraternal organizations that operate under a lodge system, but those funds that you give for those have to be used for 501c3 purposes. And what 501c3 is, it's for charitable, religious, educational, and scientific research, I think are all the categories. I may be missing one. There's also your VFW posts or auxiliary units are also considered charitable organizations. And of course, colleges such as Jefferson College. When I talk about charitable gifting, if you're thinking about giving assets for charity, I'd encourage you to look for, say, stocks that you have that have highly appreciated in value, and there's multiple benefits for that for you as a person giving that. Because just because you want to be philanthropic doesn't mean you don't need to take advantage of all of the tax breaks that are involved with it. One, it's deductible from gift taxation, so it doesn't count as a gift for the purposes of your unified credit. The charity gets the full use of it, because if you give them the stock, they can then sell it. They don't have to report any gain on it, and so no one's paying for the gain, any capital gains tax on it, and they get the entire use for that charitable purpose. Also, so you've got not only that property that you've donated is excluded from your taxable estate. It's never, as I said before, it's never going to come back in. And so you get the double dip. You get the income reduction, because you're not going to have to, if you were going to sell it, you'd have to report those capital gains. And you get the estate reduction, because it gets out of your estate and it's never going to come back in. So you're not feeling philanthropic, and you want that stock to go to family or friends. You also still have the advantage of you're getting it at least partially. You're going to get the income reduction, because you're not going to have to claim the capital gains if it's sold. You also get a benefit is if that asset's going to keep appreciating in value, the value of it on the date you give it away, that's the most that's ever going to come back into your estate. So if you give away tangible property worth today $750,000, but you expect that in 5 to 10 years it's going to be worth $2 million, and you transfer that to your son, that transaction will actually ultimately reduce your taxable estate by $1,263,000. And that's because all that's going to come back in to your estate is the $750,000 minus the $13,000 exclusion amount. So if you had kept it, that whole $2 million would have been includable in your estate. But since you gave it away, you actually saved yourself the $1,263,000 in taxable estate. A lot of people don't understand what the generation skipping tax is also. This is a tax that is imposed on transfers outright or in trust to beneficiaries who are 2 or more generations below the transfer. The IRS has caught on to the idea of, well, I'll make sure that they don't get to tax it for a while. I'm going to skip my kids, and I'm just going to transfer it to the grandkids. Well, this also applies if you're going to give to friends also. And what you have to look at when you're determining whether, say you have, you're making your estate plan, or you're deciding what gifting you're going to do, or thinking about doing some gifting. And you have little Sally down the block who is just like a daughter to you. If little Sally is more than 37 and a half years younger than you are, she's considered a skip generation. What that is you are allowed to gift to the generation below yours without incurring any generation skip tax. And the generation skip tax is the same, it's along the same lines as the gift tax. You still have that same exemption of $5 million on that also. So, but if a person is considered to be within your same generation if they're within 12 and a half years of you. The first generation is then 12 and a half years to 37 and a half years after the transfer, and the transferor is the person who's giving the gift. And like I said, anyone born 37 and a half years after the transfer is considered a skip person. And there are exceptions to that. Say you have grandchildren whose parents are deceased. If a parent is deceased and that parent was your child, you can give to the grandchild without it being a generation skip. But that only applies if they're your lineal descendants. You can't have, it doesn't apply to if, say, your great niece or anything along those lines, if their parent is deceased. It's only a lineal. It's not along the collateral. Spouses and former spouses are assigned to the same generation as the spouse. So if you have a much younger wife or a much younger husband, any gifts, those are considered those are the same generation. And so if you have somebody who's adopted, that adopted individual is treated as in being the generation below the adopted parent. We're going to skip I originally did this for a seminar I did for attorneys, and the examples, I think I've kind of explained it. As I said, the annual exclusion amount for both gift and GST purposes in 2011 is $13,000 per transferee. Now there's an exception for that. If you're giving away a future interest, that does not count towards the exclusion amount and has to be reported. The lifetime unified credit for both gift tax and generation skipping tax is currently $5 million. That is subject to the 2012 sunset provisions, where at the end of 2012, we don't know yet what the legislature and Congress are going to, and the president are going to put into effect in regards to estate tax and gift taxing. There's ways to maximize the annual exclusions. You can do split gifting. So you can treat, each spouse can give up to the $13,000, so you can give up to $26,000 as a couple per donee. There are some caveats for that. You must both of the spouses must be U.S. citizens, and they have to be married at the time of the gift. You can divorce in that year, but you cannot remarry before the end of the calendar year for it to be considered split gifting. There's also, for purposes of education, you can transfer up to $65,000 in 2011 to a qualified tuition program, a 529 qualified tuition program, and have that treated for gift tax purposes as being made over a 5-year period. So you can count that as the exclusion amount for that child that you've set that program up for, and it goes out over a 5-year period from the date of the gift. As I said, the way to maximize these exemptions is direct tuition payments. You can also make direct medical payments, and those are considered, those are not brought back in because those also fall under the type of 501c3 gifting. You can also use irrevocable trust. The one I wanted to focus on was the charitable remainder trust. You can set up a trust as an irrevocable trust and gain tax benefit by having the ultimate beneficiary be a charity, whether it be a college, a university, or a hospital, or a school. We've already talked about that. Reporting to the IRS. Whenever you give in excess of the exclusion amount, you are required to file a gift tax and GST tax return, which is a Form 709. Now, and you have to think about this because a lot of people they want to come in as part of their estate planning, which I don't recommend, and they just want to put a kid's name on the deed. Technically, that's a gift, which would require that you determining what that value of the property is and reporting that gift. There are a lot of disadvantages to just putting somebody's name on the deed for estate planning purposes. Jack one of them being that person's creditors can then come after you, after the property that you've put their name on. 2, if you, instead of putting a name on a deed, if you do what Jack was talking about with a beneficiary deed, when that property passes, currently it's going to pass with what's called a step up in basis, meaning that if they were then to sell that property, the basis for that property would be the value as of your date of death, as opposed to what might have been the price of the property when you bought it. And these are all the things that are required going back to, I also go off on tangents occasionally, but in reporting to the IRS, you have to acknowledge the current taxable transfers and GSTs of prior years. You also need to know what the basis of the property was that was transferred, and you have to indicate the value as of the date of the gift. And for any stock or closely held entities, you have to include the QSIP or the EIN number for that business. I don't think I updated this. I gave this presentation back in 2009, and I think that the GST, I think the rates are still the same, but they may not be. They may have changed with the 2011 or the December 2010 Act. As I indicated, I thought I was the one doing powers of attorney. As Jack indicated to you, there are several types of powers of attorney. There's the general power of attorney, which, as Jack indicated to you, ends upon incapacity. There's the durable power of attorney, which is meant to survive incapacity, or you can even have it not even go into effect until incapacity. And then there's the healthcare power of attorney. The general power of attorney is more appropriate for temporary powers. Say you have, say you're going to go on a trip and you want to leave the kids with grandparents. You want to have those grandparents have the authority to obtain medical treatment for your children in the event that something happens while you're gone. So you can leave them with with a power of attorney that applies only to medical care. Or you might be giving somebody a one-time authority to execute a document for you. Those are the more typical types of general powers of attorney. On the durable power of attorney, the advantages are that it survives incapacity or doesn't even come into effect until upon incapacity, and that's what we call the springing power of attorney, because it springs into effect upon your incapacity, so it leaves somebody who can execute the powers that you've granted in that durable power of attorney. In a lot of cases, it can negate the need for a guardianship or conservatorship. There may still be situations where where that will still come into a play, especially if you have a situation where somebody might have granted a power of attorney but not want the power of attorney to boss them around in ways, and so you might have to still do a guardianship or conservatorship. It also has an advantage in that you can name who your preferred guardian would be in the event that the power of attorney were not sufficient. That also has the advantage of there's a statutory fiduciary duty on the part of the attorney, in fact, to act in your best interest. And you can, they supposed to be theoretically unable to self-help themselves. There's also the advantage, I almost want to ask, how many have thought that just to be a good idea to just put a child's name on your bank accounts just so that they can help you out? When you do that, you're giving ownership, partial ownership to that child, which then allows that child's creditor to potentially attach to that bank account. Whereas if you have them acting under a power of attorney, that individual, they have no ownership interest in it. They are only acting in a fiduciary capacity, so it's not, their creditors are not able to attach to it. As Jack said, with medical directives, they've become more popular as technology has advanced. And what medical directives do is they direct what medical procedures you wish to have performed when you cannot communicate your wishes. I sometimes have people come in who are like, well, I don't want so-and-so to have the ability to just pull the plug on me, whenever they want. I'm like, well, these don't go into effect unless you can't communicate. And they're not, most of the time, they're not going to want to do that anyway. But prior to 1985, and this is what the Cruzan case kind of turned on, and she was very young when the automobile accident she was in happened, is the idea of informed consent, being that did she portray any feelings to anybody of what she would want her treatment to be in the event that she could not communicate it. After the Cruzan case, it kind of became more of a hot topic item, and in 1991 is when the Durable Power of Attorney for Healthcare Act was passed in Missouri. And you might have heard both. There's a healthcare power of attorney and there's a living will. I tend to prefer the healthcare power of attorney because with a living will, you're not directing anybody to make decisions for you. You've just, in a living will, what you've done is you've stated what your desires are. But the healthcare power of attorney allows what the living will doesn't, is you to appoint somebody. And one of the advantages of that is if you end up, somehow, treated by a hospital who does not want to follow what the living, for either there's some type of religious hospital that won't follow that or some other item, what the healthcare power of attorney allows is that gives that attorney who you've named, Jack referred to it as agent in the documents called attorney in fact. It allows the attorney in fact to then move you from that hospital. You're also, with the healthcare power of attorney, able to make what's called a HIPAA release declaration. So you allow your agent to be able to obtain your medical records, which might be beneficial if they wanted somebody else to look at your case, if they wanted a second opinion. Whereas in the living will, you don't have that option. In a healthcare power of attorney, some of the things you might consider including would be hydration and nutrition. Traditionally, and I think it's changed, but when it was first passed, and this was part of the Cruzan argument also, is that the living will tends to deal only with medical treatment, and hydration and nutrition is not part of medical treatment. If you do not want hydration and nutrition, if you are within the dying process, you have to specify that in your power of attorney or living will. You might also consider whether you want organ donation and you want your attorney, in fact, to be able to authorize that. You can also, I've ran into it a couple of times where individuals did not believe that the person who would likely be making the funeral decisions would follow their burial designation. There's a statute in Missouri that grants what's called the right of sepulcher, and what sepulcher is the right over the body. And so you can, in a power of attorney, designate who has that right. And you might also, if you have any procedures that your religion doesn't allow you to have, you would specify that in the power of attorney also, and like I said before, you'd have the HIPAA authorization. Jack's right when he stated that the biggest thing in determining on a power of attorney, the most important thing is picking an attorney in fact who is right for you. You want somebody who's trustworthy, mature, especially with a healthcare power of attorney. You want someone who knows what your wishes are and who you believe will fulfill your wishes. I mean, kids have a hard time. You don't want to let your parents go. So you want to make sure that the child you pick to make those decisions for you, or spouse, that they're going to fulfill what you want done and not what's best for them. They need to be able to do what's best for you and what you wanted.